Welcome to everybody to the DUI Legislative Update for 2015. This has become an annual practice for us to put a webinar together about a week before the new laws go into effect, with the goal of making sure that you know that the new laws are out there so that you can charge people properly if you're an officer, and you can present your cases properly if you're a prosecutor. So we'll get on with it, and we'll start by saying a special thanks to two groups: the National Association of Prosecuting Coordinators, the NAPC. They have a fund from the National Highway Traffic Safety Administration that makes this go-to-meeting contract available to all 50 states. So anybody in any of the 50 states can host and put on a webinar of this sort, any of the traffic safety resource prosecutors. So I want to thank you for joining us so that you can become informed, but especially I want to thank the National Association of Prosecuting Coordinators and the NHTSA. A couple of quick resources. If you are not already aware of our website, this is the website address, and we put a lot of things on this front page under the folder called Resources. Anyone in the general public can see anything that we have on this page. We have all of our newsletters going back 12 years, and there's a lot of case law updates and things of that sort in the newsletters. Over to the right, as you look at your computer screen, you'll see a thing that says Members. And in order to be a member, you must have a username and password. That's where we keep the good stuff. That's the stuff for prosecutors and law enforcement officers only. So we have a lot of different documents in there that we don't really want just the general public to see. That's for us, including our trial manual and a lot of different question and answer types of sheets for preparing for trial. So if you're not a member only, send an email to the email address that you'll see for Chris Morganson, who's a member of our IT staff here at the Tennessee District Attorney General's Conference. We also maintain a blog. This is my blog. I'm the one who posts everything that's on the blog. We try to keep you up to date with what's going on from the perspective of prosecution. One of the reasons that we started the blog was because every time you would type in Tennessee DUI, the only thing that would come up would be a bunch of defense attorneys advertising their positions as defense attorneys. We wanted other things to come up, things that made sense, things that made people aware of what the real problem is with DUI in our state. So we started this, and now when you do a search for DUI in Tennessee, this is one of the first things that'll pop up in your screen. All right, so now we'll get on with it. With the laws of 2015, and I've titled this the Year of Sentencing Enhancement because most of these laws, not all, but most of these laws have to do with sentencing in vehicular assault and vehicular homicide types of situations. So the first one I want to make you aware of is the Aggravated Vehicular Homicide Sentencing Bill. It was Public Chapter 433. From now on, if someone is convicted of an aggravated vehicular homicide, they have to serve, their sentencing range is 60%, and they cannot be released prior to serving at least 45%. And so their good time credits and all of that cannot account for more than a 15% reduction on a 60% release date. So if you get 10 years, they have to serve at 60%, which would be 6 years. They can get it down to 4.5 years of good time and all that kind of stuff, but it's much better than the way it was, where it was a 30% service. Now, this bill was sponsored by Senator Overby from Maryville, Representative Carr, and it was named in memory of Ben Woodruff and Mike Locke. So just very briefly, this is Ben Woodruff with his children. He was killed by a 5-time DUI offender over in the East Tennessee near Maryville. This guy was on Xanax and crack when he killed Ben Woodruff, and Ben's son Ethan received severe brain damage that the family will deal with for the rest of Ethan's life. Ben's wife, Beth Woodruff, got with Knoxville attorney Darren Berg, and when she found out that the release date was so quick for somebody, even with 5 prior DUIs. They took the ball and ran with it. They went to some legislators and they worked for the passage of this law. So a tip of the hat to Ben's wife, Beth Woodruff, and may he rest in peace. And let's all just hope and pray that Ethan will heal better than expected. The other person who this is named after was Mike Locke. Mike Locke is a former state representative and a Kingsport businessman. He was killed by a hit-and-run driver while he was putting up campaign signs for current Representative Bud Halsey. And so that got the attention of the legislature. They really do pay a lot of attention when one of their own is killed by a drunk driver. That's it's a shame that it takes something tragic in order to really grab their attention, but sometimes that's what happens. The next bill, Public Chapter 125, had to do with sentencing in vehicular homicides and in vehicular assaults. And that no longer can a person get straight probation for one of these crimes. This requires a person who commits vehicular homicide or assault to serve at least as long as they would have for the underlying DUI. So if it was a third offense DUI that turned into a vehicular assault case because someone was injured, they will have to serve at least 120 days now, whereas before they could get straight probation, which was just plain stupid. A lot of credit goes to Beth Warren with the Memphis Commercial Appeal. She wrote an article, and a series of articles actually, in the Memphis paper called A Tennessee Anomaly Allows Probation for Drunken Drivers Who Cause Fatal Crashes. This thing went state and nationwide. The AP picked it up. And as it says on here, legislators reacted well. I was even quoted in that story saying, what sense does it make that a person who kills or injures does less jail time than a person who commits a straight DUI and doesn't kill or injure anyone? So the legislators grabbed it again. It was Senator Overby, and it was Representative William Lamberth, a former prosecutor from Sumner County, who got that law passed, and I want to give them credit and applause. The next one, also from Representative Lamberth and Senator McNally, created for the first time ever an aggravated vehicular assault law. After July 1, if a person commits a vehicular assault and they've got priors, they may be an aggravated vehicular assaulter instead of just a vehicular assaulter. So it requires that the vehicular assault sentence be enhanced if there's and it requires this. This is not a maybe. The law says they shall be charged with an aggravated vehicular assault if there's a history of DUI or habitual motor vehicle offender violations, which is really cool. So here's how it works. The look-back period for aggravated vehicular assault is 20 years. There's no 10-year cap. There's no looking for 10 years to see if there was a prior and then going back another 10 years. This is a straight 20-year period. And there's no requirement to have both the arrest and the conviction within that 20-year time frame. The conviction has to be in the last 20 years. The convictions that count are DUI, habitual motor vehicle offenders, vehicular assaults, vehicular homicide by intoxication, and aggravated vehicular homicide. This is the first time that any of these sentencing enhancement statutes have included convictions for the Habitual Motor Vehicle Offender Act. So that's a big deal as well. So if the driver has 2 prior convictions, or 1 prior conviction and a 0.20 blood alcohol level, this sentence is a C felony instead of a D felony, and the fine is $5,000 to $15,000. Now that 2 convictions or 1 with a 0.20, that's the same way we look at aggravated vehicular homicides to see if that law fits. So 2 priors or 1 prior with a 0.20, and remember to include your habitual motor vehicle offender convictions. The next one having to do with vehicular assault or vehicular homicide affects the bond situation. Public Chapter 490 now requires that if a person has a prior and is charged with vehicular assault or vehicular homicide by intoxication, the person as a condition of bond, shall be ordered to wear one of these transdermal monitoring devices. The transdermal monitoring device, one of the companies is Scram, but there's other companies as well. Those monitor whether the person has consumed any alcohol at all. Now, they have a cutoff of 0.02. So they might not catch it if somebody has a beer, but they will catch it if they have two. So the priors that count for this one are DUI, vehicular assault, vehicular homicide, and aggravated vehicular homicide. For this bond condition, the Habitual Motor Vehicle Offender Act does not play a part. Only the DUI, vehicular assault, and the vehicular homicide convictions. The sponsors of this one were Senator Mike Bell from over in Athens, Tennessee, and again, Representative Lamberth, who was a DA, assistant DA in Sumner County. One other thing about this law, it adds a Class B misdemeanor if a person tampers with the device, tries to remove it, tries to cut it, tries to do any of that kind of stuff. And it specifies that a judge can revoke the bond of the person if they tamper with this device. So that gives a specific authority to the judge to revoke bond if any tampering goes on. Now, if you want to know more about alcohol monitoring devices, note that on our website in that resources folder I showed you at the very beginning of this, we have put the 121-page NHTSA report concerning how these devices work and their reliability. It's in there for your reading pleasure. But I got to tell you, it's a little bit dry, but it's there. Okay, the next one has to do with one of my pet peeves. I hate it when a person hits and runs. I think that is inhumane. I think it's sick and disgusting, especially when they injure or kill somebody and then leave them behind. But this one has to do with the hit and run with property damage. Now, they've increased the financial threshold from $400 to $500. So if a reasonable person would believe at least $500 worth of damage was done, they can't leave the scene and report it later. The Class C misdemeanor has been increased to a Class B misdemeanor. However, if the person does not have insurance, it is now a Class A misdemeanor and requires a 1-year license suspension for the A misdemeanor. So the question is, would a reasonable person believe that there's $500 worth of damage? If so, it's a Class B misdemeanor instead of a C, and no insurance, it's a Class A. I'm going to put one more poll up here right now, if you don't mind. And this poll, well, even if you do mind, because you can't see me. But this is a very simple one. It's, are you able to hear me okay? Please click yes or no. Just take about 10 seconds. I just want to make sure everybody can hear. Right now it's showing me okay, it looks good. It looks like everybody's voted. Oh, there's one person who can't hear. I'm sorry about that, one person who can't hear. Whoever you are, I don't know if that's an equipment problem or if you're just getting old like me. But anyway, I'm sorry about that. But I'm not going to try to stop everything to fix it from one, because it's probably an equipment problem on your end. Okay, so next on here is this was a technical corrections bill, and the technical corrections bill is a fancy way of saying we want to get this thing passed without anybody really raising a stink about it. So the administration did this, and what they did is they returned to the language of DUI the words or on any streets or alleys. That had been taken out when the DUI rewrite occurred 2 years ago, because quite frankly the committee believed that if a person was driving on any of our streets or alleys, that person was a person who was in a place where the public drives, generally frequented by the public. So they took it out just to save a few words in the statute. It's been put back in now just to make sure it's very clear that it's illegal to drive on any of those places while DUI. And then the other thing they did is they clarified that the 7-day sentence applies to any driver with a .20 BAC or higher, because apparently some judge somewhere said, well, that only applies if you're exactly a .20. It doesn't apply if you're a .21. So they fixed it by adding that back in. It's a shame that we would need something like that, but we did. Another one I want to tell you about is the failure to yield law. This would be extremely relevant to you as law enforcement officers. As you know, in the past, it was a crime to fail to yield at an intersection. Well, somebody failed to yield, and there was a crash when they were coming off a private driveway. And if I recall the story correctly from Representative Beck here in Nashville, a motorcycle was coming down the road. A car pulled out in front of the motorcycle, and the officers couldn't charge him with failure to yield because it was out of a private driveway instead of an intersection. And apparently that's how they interpreted that law, and I believe that's how it read. So this clarifies that they can fail to yield in other places as well. So a tip of the hat to Senator Dickerson and Representative Beck for this one. Powdered alcohol has been banned by our legislature, thanks be to goodness, because this is a trend that is happening in a bunch of parts of the country where you can buy this powdered alcohol and add it to water, and the next thing you know, kids are getting intoxicated without ever having to buy their alcohol at a liquor store. So it's a Class A misdemeanor to sell this stuff, and the Alcoholic Beverage Commission may suspend or revoke a liquor license if anybody sells it at an establishment. Now, this one was a real kick in the teeth. When I first became aware of it and read it, I'm still a little ticked off about it. But our General Assembly, in its wisdom, decided that seizures of second offender DUI cars are no longer permitted until after the person's been convicted. That makes they might as well have just repealed it, because that makes no sense at all to me. If a person is a second DUI offender and they get arrested and they know that their car is going to get seized after conviction, why would they still have that car after conviction? They would sell it, they would put it in their spouse's name, they would give it to their kids, they would do something else with it just to get rid of it so that the state couldn't get it. So for all practical purposes, I think they've basically killed second offense vehicle seizures. Now, the bad thing about this is there were 866 of these suckers last year, and of course there would be an administrative hearing, and then you go from there to see if the person forfeits their car, if the person gets their car back. So there were 465 of these in East Tennessee and 309 West Tennessee. Middle Tennessee's never been big on seizing these vehicles, but that's a kick in the teeth for us. So be careful of that. Don't be seizing vehicles at the time of arrest for second offense DUI anymore. Can't do it until after conviction. I think you might be able to give them a notice of seizure that we're planning to seize it, and put them through the hassle of having to get rid of their car before they get convicted, but that's about it. The bad thing about this is it didn't look like the people who were talking about this bill, especially on the Senate side, really knew that there was a hearing process for these offenders. They indicated that these cars are just taken and sold without any kind of due process, which is silly. We have the administrative hearing judges for this very purpose, and they would take evidence and listen to these cases. Now, as a prosecutor, a lot of times the transcripts from those hearings would come back to bite us in the criminal court case, because they'd have a transcript of everything that was said at those seizure hearings, and officers were not represented by anybody there. And so defense attorneys oftentimes used those to gather discovery and then would berate the officer about it in a criminal court trial. So I don't think our prosecutors are really going to miss having those transcripts pop up on us in the middle of a trial like they did before. But it's still kind of a shame that this happened based on poor information. And the other kick in the teeth about this is that a lot of the fund from this seizure, after the expenses were paid to the agencies, would go for alcohol and drug treatment. It would go into the ADAP fund. So this is a cut to the ADAP fund, just as we're asking them to treat more drivers. But on the good side, the legislature did pass the victim photo bill. And this is in any criminal homicide, we're permitted to show a photograph of the victim while the victim was still alive. And it's a shame that we needed a bill like this to be able to do this, because in reality, it's only a few judges were ruling that it was more prejudicial than probative to show a picture of the deceased person when that deceased person was still walking on this earth. And it's a shame that we needed a bill to correct those judges who had made those types of rulings. The sponsors were Senator Bowling and Representative Weaver, and a lot of the General Assembly signed on as co-sponsors after the process started. I want to say that this was a joyous day. It's the first time I ever went and watched a bill get signed. And you can see the important people in this picture up here in the front. There's Governor Haslam with the little girl holding a picture of her daddy. And there's a lot of our elected DAs and some of our state representatives and senators right there in the first couple of rows. If you look at the very back row where there's an arrow pointed at me, well, that's because I wasn't one of the important people here. All of the victims in this thing were the most important people there, and we're so pleased at how happy they were to get this bill signed. They thought it was a tremendously joyous day because they were remembered. Their loved ones were remembered, and people didn't look the other way and forget about them and act as if this wasn't a big deal. So it was a particularly joyous and happy day, and that was a very, very big deal. And I want to give a lot of credit to our conference, to Guy Jones, our assistant director, and Wally Kirby, when he was working with us as our director. They carried a lot of the burden on getting this bill passed. It took a couple of years to get it done, but then also all the DAs that participated in that, particularly people like Mike Donovan and Steve Crump and some of the others who would come up and testify. So kudos to them for getting this passed. And folks, that's all the laws I've got. That's the end. And so I appreciate you joining me for this